So this made me laugh a little bit, never because I need a cookie for being right, but because I've been beating the same drum over and over recently. When someone says risk, what exactly has been established? Not what could happen, not what somebody is afraid might happen, not what the charge makes somebody feel like might happen, but what facts support the prediction and what connects those facts to the conclusion. And then I go digging through Supreme Court cases and find Stack v. Boyle. Government wanted unusually high bail based on an assumption that these defendants would flee, and the Supreme Court actually calls out the problem, assuming without the introduction of evidence. There it is. That's the issue. Not risk isn't real, not courts can't consider risk. You made a consequential assertion. Show us what supports it. And then Tot comes along. There needs to be a rational connection between the fact proved and the ultimate fact presumed. Hello, weak bridge. You have fact A. You want the court to arrive at conclusion B. What's between them? Because sometimes there is a solid bridge, and sometimes you've got two popsicle sticks, duct tape, and prosecutorial confidence. And this is where it gets even better. This is more than just some goofy theory. Salerno upheld preventative detention under certain circumstances, but the court still says liberty is the norm. Detention is the carefully limited exception. So now we're actually getting somewhere. The question isn't, is risk an offer? The better questions are, what risk? Based on what? How was it established? What's the evidentiary bridge? What burden applies? What alternative was considered? And what exactly did the judge find? And for everybody who watches court and thinks, man, this sure looks like winner-take-all warfare, apparently the Supreme Court noticed that problem a long time ago too. Berger v. United States says that the prosecutor's interest isn't simply to win the case. The interest is that justice be done. Hard blows? Sure. Foul blows? No. Then the Supreme Court gives us this beauty. Too great an analytical gap. Different kind of case, but look at the reasoning. Data over here, conclusion way over there, and somebody forgot to build the middle. That's what I've been trying to get people to see. And Brady says society doesn't win merely because somebody gets convicted. Society also wins when criminal trials are fair. So no, I'm not putting these cases up here to yell, look everybody, I invented something. I never did. That's actually the cool part. I'm showing them because maybe we can stop wandering through endless theories and start recognizing the pressure points the law itself keeps identifying, such as evidence, burden, inference, individualization, testing, findings, record. Maybe instead of trying to discover some secret court language, we can get really, really good at noticing when somebody skipped a step. Because if an accusation becomes an assumption becomes risk, risk becomes a finding, and the finding becomes a loss of liberty, then the place to look is in between the steps. Find the fact, test the bridge, identify the burden, and demand the finding. That's far from magic. That's just thinking.